World events make you think about the future. You need a plan. Explore the differences between a last will and testament and a trust-centered estate plan. Brought to you by Purple Law Firm in Chattanooga, Tennessee. Now, let's discuss the different categories of estate plans. The most commonly thought of document is a last will and testament. But there is another category, or type, of estate plan. That is a trust-centered estate plan. In this video, we will explore the benefits of both. Since most people are at least vaguely familiar with a last will and testament, we will focus on a living revocable trust first. A living revocable trust is a contract, which is entered into by multiple parties, of your choosing. For example, a husband and a wife. Maybe, a parent and an adult child. The trust agreement contains the specifics of how you want your estate handled in certain situations. What are the major benefits to a revocable trust? A trust is effective immediately, during your lifetime. A trust does not require probate, or court supervision of any kind. A trust-centered estate plan manages your assets now and later, both during your lifetime and after death. A trust provides for flexible distributions of assets after death. This would include continuing the trust to provide for the management of a minor child's share, or a share for an adult child, in certain instances. By the way, you choose who manages your trust and your assets when you are no longer able. There are even more benefits of a revocable trust. A trust provides protection from certain creditors. Obviously, a trust is not intended to help you escape legitimate debts. But a trust does protect you from certain unforeseen liabilities. For more details, you would need to speak to an estate attorney. A trust-centered estate plan prevents the need for a conservatorship or guardianship if you are incapacitated in the future. A revocable trust helps your family to avoid the process of probate, which can be very expensive and may drain the estate of any value. A last will and testament, as you may already know, provides for the payment of debts and the distribution of your property upon your death. You choose who gets what property when you die. You also appoint a person of your choice to serve as the executor of your estate. Now, let's discuss a few things about a last will and testament you may not already know. Unlike a trust, a last will and testament is only effective upon your death. In other words, it is only designed for post-death distributions. A will, to be effective, usually must be probated by the courts. The court officially appoints your executor to serve on behalf of your estate. The court then supervises the administration. The probate process usually involves many steps that are required by law. Because of the requirement to probate, a last will and testament has substantial extra costs involved after your death. This includes attorney fees, administrator fees, and court costs. So, let's review the pros and cons of a last will and testament. The advantages to a will are as follows. Number 1, a will is quicker to prepare. 2. A will is a simple approach to planning your estate. 3. A last will and testament requires lower upfront costs. The disadvantages of a last will and testament-based estate plan are as follows. A will provides no benefits during your lifetime. A will requires probate. It is more expensive in the long run. A last will and testament can be challenged in court after your death. Also, a will can be readily attacked or challenged by your creditors. Let's do a quick side-by-side comparison of a revocable trust and a last will and testament. A revocable trust provides management of your estate during your lifetime and after death, without the need to probate or take any court action. You choose your own managers, again no need for court involvement. A trust provides very flexible ways to distribute your assets. A last will and testament is only effective after death. No benefits during your lifetime. A will requires probate by the court, which includes court approval of your chosen executor. A will is less flexible than a trust in terms of distribution of assets. In the long run, all things considered, a last will and testament is more expensive than a revocable trust. We've discussed a last will and testament and a revocable trust. But what is a trust-centered estate plan? A trust-centered estate plan is a trust agreement with several additional documents. A complete estate plan involves more than just asset management. So, a trust-centered estate plan includes the following. The trust agreement, which is the central part of the plan. A schedule of your assets in the trust. This keeps private information separate from the trust agreement. documents to transfer assets into the trust. For instance, a quitclaim deed to place real estate into trust. Also, letters of instruction to banks and insurance companies. A certification of trust. This is a document which can be publicly recorded, discloses information about the trust and trustees or managers, but keeps private information, like distributions, private. A trust-centered estate plan also includes a last will and testament, called a pour-over will. This is prepared as an extra precaution, just in case an asset is outside of the trust at the time of your death. The will provides that such an asset be placed into the trust and managed according to the trust agreement. A trust-centered estate plan also focuses on needs other than strictly asset issues. Therefore, a durable general power of attorney is also prepared. This allows your successors to manage other business for you when you are unable. Furthermore, in the event that you are incapacitated, your healthcare decisions are extremely important. Therefore, a durable power of attorney for healthcare and a living will declaration are also part of a trust-centered estate plan. All of these documents can be amended in the future. So, if circumstances change, you can change your plan to fit. A trust-centered estate plan is a complete plan for your future.